Dear college, good afternoon, good evening, or good morning, depending on the time zone from which you are accessing online this event. I extend my gratitude to all of you who have joined us in this room and those of you who are following us at the virtual room. This is the second occasion on which we have participated in the General Assembly of IGER, the Interest Group on Emerging Rights. The initiative was, thank you for closing the door. This initiative was first proposed 1 year ago and at ICON's annual conference in Wellington, New Zealand. At this event, several resources contributed to the formation of a collective understanding of the rationale for establishing an interest group within the International Public Law Society. The recording of this presentation is still available online for public viewing in that web. Subsequently, the presentation or application was approved, and we are now the 16th interest group to be formally recognized by ICONs. The group is structured in such a way that scholars hailing from different countries may serve as ambassadors within their respective countries for the advancements of the network. In this geographical distribution, we have endeavored the maintenance a balance between Europe and America. In the former category, we have researchers from France, Italy, Germany, the United Kingdom, and Spain. In the later category, we have researchers from Argentina, Canada, Colombia, Ecuador, Mexico, and Peru. Furthermore, we have striving to ensure that the group encompasses a diverse range of legal scholars, including constitutionalists, internationalists, administrativists, philosophers, and sociology of law. This multidisciplinary profile is needed to facilitate an interdisciplinary approach, which is considered the optimal methodology for studying the subject matter that units. While we have not yet achieved optimal gender parity, there is a balance between men and women, and at least 2 generations of researchers are represented. It is our contention that this local research will facilitate the development of the interest group in a number of ways. These include the formation of the group's teams, the dissemination of relevant information, the organization of academic activities, and the incorporation of members into the project. In this context, we would like to utilize this framework to propose 3 initiatives. Firstly, it would be advantageous to establish an IGER website as a reference and meeting point. A preliminary attempt at establishing a website for the IGER was made on the website on the Law and Justice Research Group, which I did. The website can be accessed at the www.derechoyjusticia.org. So that's why. This platform would serve as a repository for all available information, including academic events, bibliographical news, regulatory or jurisprudential news, publications, and other relevant materials. Furthermore, the platform enables the implementation of a chat function which can be populated with contributions from any members of the network. Although a moderator will be present to prevent unacceptable, aggressive, or untimely interventions, the participation will be open and free of any such restrictions. The second initiative is the publication, perhaps a quadrimestral newsletter. In this forum, we will collate the information that becomes available, and we hope that this forum will become the ordinary space for the dissemination of information among members the IGER community. Finally, it is proposed that 2 or 3 mixed meetings, face-to-face and distance, will be held during the 2024-25 academic year. One potential venue for this event could be the ICON's annual conference, which is typically held at the beginning of July. An alternative or complementary option will be to select a different framework, such as the Law and Society Conference in Chicago or the LASA in San Francisco, perhaps. Finally, a purely virtual meeting will be held at another time of the year. Furthermore, it will be advantageous to extend an invitation to each IGER participant to organize or promote activities in their respective field that may be of interest to them in terms of subject matter. With regard to the latter, it is my option that it's not appropriate to provide a more detailed account than that set out on ICON's website. The interest groups' research activities are concentrated into 2 principal areas. The initial area of focus is primarily theoretical and involves establishing the foundations and conceptualization of those novel rights, as well as exploring new dimensions of traditional rights. The second line of inquiry pertains to applied research, which encompasses the analysis of these concepts and their particular evolution within diverse constitutional, supranational, and international contexts. In this session, we will examine 3 examples of the subject matters versatility, and dynamism. The initial presentation will be delivered by Colleen Sheppard, SFR Scott Chair in Public and Constitutional Law and Professor at McGill University in Canada, and the title is Toward a Constitutionalism of Inclusion, Emerging Rights for Marginalized Individuals and Groups. So I give you the floor.
She's connected.
But
I just saw her before. Now maybe she's Maria Elósegui.
Yes, she was connected.
She was connected before, but now.
No, it doesn't matter. Just in your email, you said she was going first if she's waiting.
No, she's connected. She's connected.
Oh yeah, she's over there.
Maria, if you want to speak first.
Yes, if you want, as you want.
I can go ahead.
Okay.
Okay.
Thank you. Slides.
Hola.
Okay, can you see me?
I think we're gonna start with Professor Sheppard first, if you don't mind.
Okay, I don't mind.
Okay, gracias. Hola, estoy muy contenta de estar aquí nos toca con ustedes. It's a real pleasure to be here, and thank you, Jose Maria, for all the work you've done in bringing us together to think about emerging rights, a theme that allows really for a wide range of thinking about rights, discourse in diverse and myriad contexts, as I think the diversity of the presentations for today demonstrates. In my presentation, I'm going to explore, the title is Towards a Constitutionalism of Inclusion, thinking about how we might provide meaningful human rights for marginalized groups and communities. I think in a context of deepening socioeconomic and structural inequality, where we see work and immigration status precarity, devastating and disparate impacts of climate change, inequitable effects of war and social violence, the continuing effects of colonialism, social isolation and exclusion. It's critical to think about how we translate those realities into effective human rights. Just a note on terminology, I'm still working with different terms, but I've used marginalized communities to put the emphasis on how more powerful groups marginalize less powerful groups. I've noticed since being in Europe for the last month, a lot of usage of the terminology of vulnerable groups, or in Canada, people often say groups in situations of vulnerability to emphasize the social construction of vulnerability, or socially disadvantaged groups, but for now I'm talking about marginalized groups. Okay. So in terms of my outline, I'm going to focus on the first part, the interpretation of rights, perhaps in the more theoretical strand that Jose mentioned. And I'm going to focus on how we might ensure an expansive interpretation of rights that are already recognized, but often given interpretations that may not resonate with the needs and realities of marginalized communities. We also may need to develop new concepts and categories within existing rights, an example being perhaps intersectionality, which has emerged with respect to discrimination law. And we may need new rights, but my focus today really is on an expansive interpretation of rights, and focusing in particular on the right of equality. Secondly, I'm going to just briefly touch on the idea of how we ensure respect for human rights, which touches a little on the applied, but as we all know, if you don't have effective rights on paper are not sufficient. So, so an important starting point, I think, for thinking about emerging rights is recognition. And this is an idea from Upenda Bakshi, which I find his work quite interesting. And he suggests that constitutionalism provides contested sites, and I'm focusing on rights through the lens of constitutionalism, but I think statutory and the international human rights domain raises similar issues. He writes that constitutionalism provides contested sites for ideas and practices concerning justice, rights, development, and individual associational autonomy. Constitutionalism provides narratives of both rule and resistance, which really, I think, recognizes that there's a space, an interpretive space, and a space for thinking about alternative definitions, that we don't simply have an objective body of constitutional rules, but rather we have a continued contestation about the meaning and content of those rights. Similarly, Bakshi writes that rights interpretation should not be done exclusively by state actors. And I think this challenges us as jurists, who are used to focusing on judicial and legal scholarly interpretations of rights. But he writes that there is violent epistemic exclusion when one focuses merely on the state or law production of human rights, that suffering and repressed peoples remain the primary authors of human rights, values, and visions. So as I say, I think that's at odds with the traditional hegemony of interpretation by jurists, but it recognizes the importance of building new rights, emerging rights, based on experiential knowledge of marginalized communities, and that in turn is integral to a contextual approach to interpretation. And this photo in the slide here depicts the housing crisis in Indigenous First Nations communities, the Attawapiskat Indigenous community in Ontario, Canada, where we see a question of the importance of asking the question, how do the individuals in those communities conceptualize of rights, housing rights, equality rights, rights to liberty, security, the person, privacy. So More generally, at least in the Canadian context, there's growing recognition of the need to apply contextual methodology to constitutional interpretation that's informed by experiential knowledge and the realities of socially disadvantaged groups. I take this is a quote from Justice Bertha Wilson, who championed contextualism in her judicial opinions. And she was also the first woman to be appointed to the Supreme Court of Canada back in 1982. And she wrote this in a speech on women's rights. She says, real lives, contemporary women's lives should not only be taken seriously, but should be regarded as primary in interpreting constitutional guarantees. She did a lot actually on reproductive rights and reimagining the scope of reproductive rights pursuant to the idea of security of the person in the Canadian Charter. Experience, she said, must not be shoehorned to fit within the constitutional guarantees. Rather, the constitutional guarantees must be interpreted in a way that is responsive to women's reality. So again, it's more of a bottom-up approach rather than a top-down approach to interpretation. In a similar vein, Professor Mari Matsuda, who does critical feminist race theory, has proposed what she's called a weighted pragmatic method, weighted in terms of giving, seeking, as she puts it, to retrieve subordinated voices in order to attain a truer account of social reality and human possibilities. Just one other point on contextualism, and this is a slide I've used in thinking about the meaning of systemic discrimination, but I think it's also relevant to contextualism. When we're thinking about rights, I think it's important to think about them in three different layers of rights. The micro level, that is rights violations and interactional injustices between individuals. The way those are situated in institutional contexts, which I call the meso level. Some scholars use meso to refer to national, but I use it to refer to the institutional policies, laws, workplaces, educational institutions, corporations, if we're thinking about potentially corruption in one of the presentations. Those micro injustices are linked to meso contexts, which in turn are linked to the macro level of rights violations. That is the broader historical intergenerational patterns of exclusion embedded in public laws, and constitutional contestation often occurs at that macro level. Litigation is often difficult to achieve at that macro level, although we'll come back to that in a moment. Okay, so that's sort of a contextual approach, and I think is critical to emerging rights. A second idea is the idea of interdisciplinary concepts and insights. And I think that I have found, at least in my writing and work, that turning to scholars outside of the discipline of law is a fruitful source of insight and creativity that can help, I think, to advance expansive definitions of rights. And the one I'm just going to use as an example and as a focus, and it's partly linked to a research project that I'm doing, is the concept of social inclusion, or its counterpart, social exclusion. And you can see here's a definition of it from Ann Tackett, who's public health scholar, I should say, in a book entitled Practicing Social Inclusion. And she defines social exclusion as a complex and multidimensional process driven by unequal power relationships, interacting across the economic, political, social, and cultural domains at different levels, the individual, household, group, community, country, and global levels. And she emphasizes that it involves a lack or denial of resources, rights, goods, and services, and the inability to participate. This idea of social exclusion resonates, I think, very closely with many concerns of human rights. And yet it's not a term, unlike actually vulnerability, but social inclusion, I don't find, in my searches at least, I haven't found used in legal opinions. It's not widely used. It's more often used in other disciplines, sociology, public health. It's widely used in government and international reports. And what I think is important, and which I'm going to come back to with respect to an expanded notion of substantive equality, is its emphasis on both substantive conditions of inequality as well as participation or process concerns, which I think are often excluded from our considerations of equality. Just to give another definition, this is from a UN report, social inclusion is defined as a process of improving the terms of participation in society, particularly for people who are disadvantaged, through enhancing opportunities, access to resources, voice, and respect for rights. Now, there is an extensive literature on the meaning of social inclusion, which I've been reading, as well as numerous critiques of the concept. And I'm not sure I'm going to stick with it, but for now I am. Some critique it for emphasizing inclusion, sort of neoliberal market inclusion under precarious and inequitable conditions. This focus of you must work fair, you must access the labor force in order to obtain social security. But I think it has the potential to reinforce a more just and expansive interpretation of certain human rights and constitutional rights. And I'm just going to highlight a couple points on that. Okay, in an important article back in the early 2000s, legal scholar Hugh Collins wrote about social inclusion, particularly with respect to anti-discrimination law. And one of the things he emphasized was that social inclusion as a legal concept does not seek the same or broadly equivalent outcomes for citizens. It concentrates its attention not on relative disadvantage, but on absolute disadvantage of particular groups in society, which resonates more with the marginalized communities idea. And the targets include typically child poverty, unemployed youth, racial minorities, and deprived neighborhoods, not the more generalization of individual welfare. So he then relied on this asymmetrical concept of social inclusion to justify differential treatment, accommodation, sort of remedial responses to adverse impact discrimination. In a previous paper on social and economic rights, I relied on the concept of social inclusion to suggest that it might provide a more principled basis for extending and potentially limiting the reach of socioeconomic rights. I found in the Canadian jurisprudence that judges were not moved simply by empathy for the inequitable living conditions of vulnerable or marginalized groups. They needed a principle to frame their analysis of social rights. And I suggested social inclusion. They haven't adopted that yet. So that it might provide such a principle to reinforce an interpretation of the right to life, security of the person that would impose more positive obligations on state actors with respect to health, shelter, welfare, and education rights. Now, I'm going to skip over this one, but in doing this research, I came across interesting work by philosopher Kimberly Brownlee, a Canadian philosopher, who is suggesting the need for an emerging right as sort of a part of social rights against social deprivation. And this photo from the COVID era of an elderly woman in a retirement home, I think, provides a visual depiction of this concern. And she defines social deprivation as, and it's linked closely to social exclusion, to a lack of minimally adequate opportunities for decent or supportive human contact, including interpersonal care, associative inclusion, and interdependent care. Okay. Now, what I want to, I'm just not sure my time here. I started, I forgot the message. Okay, but I'll try and do this. Just in thinking about implications of social inclusion on equality or on rights, I just want to emphasize that our Supreme Court and in other jurisdictions and in international sort of the general comment on anti-discrimination, there is a growing recognition of substantive equality as a philosophical premise of constitutional equality rights. Justice Rosalie Abella, champion of equality rights in the Canadian Supreme Court, wrote, substantive equality is a remedy for exclusion and a recipe for inclusion. So the question is, how do we potentially use interdisciplinary concepts to inform the meaning of a concept like substantive equality, which judges are not sure exactly how to contain it or how to measure it. It's not as easy as a formal equality conception. And what I found, or what I'm suggesting, is that interdisciplinary concept, again, just to lay out this example for one more slide, is that it helps us to crystallize the underlying purposes of equality rights, and most specifically substantive equality. as including integration without assimilation, sort of equitable integration and access to employment education benefits, non-exclusion in marginalized groups in segregated settings, where we see gregarious migrant workers, for example, even prisoners in certain conditions, older people, and also a participation, voice inclusion, and democracy element of equality. Okay, for the second part of my presentation, I just wanted to touch upon some considerations about implementing human rights. Let's go back. One, the idea of state responsibility for the implementation of human rights, but also I think it's important to think about governance and implementation beyond the state. So I just highlight a few ideas on that. In terms of state responsibility, I think we can see that number one, access to justice in courts and tribunals is critical. That we have, and there's still, with respect to groups living and individuals living in situations of marginalization, effective access to justice in the courts and tribunals is still a huge challenge. And some of the most vulnerable people are least likely to advance their claims in court. Interestingly, access to the courts is also emerging as a mechanism for contesting macro inequities. All the environmental justice, climate change work, I think, is an interesting example. The second approach I think we need to think about is that institutional meso level, the shift in the human rights domain from a command and control retroactive implementation of remedies through filing of complaints to a more reflexive model of regulation whereby institutions and organizations are given responsibilities for implementing human rights, such as employment equity, affirmative action, pay equity, sexual violence in universities, for example, some disability concerns. And this, I think, is a question about how do we diffuse or extend the responsibilities for human rights enforcement into the institutional context. It has, I think, critical advantages for effective and proactive prevention and implementation of human rights, which is obviously important. There are problems in terms of giving institutions responsibilities to then implement human rights, in that you don't necessarily address all of the power inequities that exist, or it may appear to be, it may actually reinforce certain power inequities in the guise of human rights progress. And thirdly, there's a question of state responsibilities to prevent and redress structural injustice, more of the political domain. There may be some test case litigation. In Iris Marion Young's work on structural injustice, she suggests that such injustices are best remedied through collective political engagement. However, I think there's room for all three there. So just to highlight this last idea, and that is looking at the implementation of human rights beyond the state. There's an important strand of legal pluralism jurisprudence that emphasizes that legal pluralism can actually apply to constitutional law, which is out of sync with our normal, I think, definition of constitutional law as implicating relationship between state and citizens. And here we can see legal pluralism as an understanding of constitutionalism that is embedded in community relationship practices and norms of social governance. James Tully in his work has called it eco-social constitutionalism, practices and networks of internalizing interdependency. Realize the version on the screen is not the final version. Okay, so I had edited out a few slides, that's why I'm skipping over them, apologies. So just in terms of the an example of this non-state interpretation of justice, I think one can, Tully talks about democratic cooperatives and community-based businesses, and also learning from indigenous the practices, the non-state living constitutionalism emerging in indigenous communities, which is happening all across Canada, and the reinvigoration of traditional governance systems that may enhance the protection of some fundamental human rights. So that's just as a minor point. I think if we're thinking about rights, we have to think about how they operate at the state level more formally, how rights are embedded in the relationships of everyday institutional and societal life. So just in terms of conclusion, I think we can see that emerging rights should be attentive to the most marginalized and socially disadvantaged individuals and groups. That to this end, we need a contextual, imaginative, and interdisciplinary approach. Respect of rights can happen through creative litigation, reflexive institutional regulation, and proactive engagement, and that respect for rights may be implicated in the relational context of everyday life. Muchas gracias.
Thanks a lot, Colleen. It's a pleasure to hear you. Well, now it's time for Maria Elósegui. She is professor of philosophy of law at the University of Zaragoza, and she is now judge at the European Court of Human Rights. Her paper. Hi, Maria. Now I see you.
Okay, perfect.
Her paper is entitled New Challenges in the Case Law of European Court of Human Rights. The desire of biological mothers to maintain her anonymity in the face of the alleged right of adopted adults to know their origins. So thank you very much for being spiritually with us here. And I give you the floor, Maria.
Thank you very much. Can you hear me?
Yes, we can.
Yes.
We can hear you.
Perfect. Well, then I want to start thanking Professor Sauca and also the other two speakers for this invitation to intervene in this group of emerging rights. Following the main lines of research of the group, I will focus in the analysis of some new sensibilities. It's not only related to the concrete subject, but it can be extended to many questions. I have chosen the matter of the right to know their own origins and the legal consequences and problems which have been introduced in the European Court of Human Rights of Strasbourg from the point of view of IGER, even if I am also university professor. Well, then I will show these perplexities or problems or evolution in rights with a concrete subject that is not only theoretical, although of course there is theory behind. Concretely, we have solved a case related to France, but also this culture is sometimes in the French part of Canada. A case related to France that is called Sheppard versus France, but that is an anecdote. The question is the applicant is an adopted woman who is now 56 years old, and she wanted to know their identity or the identity of her biological parents. Then here we start with the problems. In theory, it's wonderful to know their own origins, I think, as a right. And now we have new mentalities. But, well, the request concerns the refusal of the French National Council for access to personal origins. This institution is a kind of mediator, kind of ombudsman for doing this, dealing with these matters. Then this council didn't want to communicate to the applicant the identity of her biological mother, who abandoned her at birth and who has renewed currently, her desire not to reveal her identity in response to the applicant request to lift the secret of her origins. Then we start with these two rights in conflict. A woman who was a single mother with this adopted, in this case also women. Well, the applicant came to Strasbourg alleging that the denial of the French authorities to give her such an information goes against the right of private life, her private life. And we have an article in the European Convention, Article 8, about this right. The judgment in which I have participated by majority of 6 judges against 1 did not give reason to the applicant, but confirmed the decision of the French courts and authorities. For understanding that, I want to explain a little bit the context. In order to understand the situation and the conflict of interests involved in the case, we need to know the concrete French legislation about this matter. The discussion in the French society, the debates on the changes in the law of bioethics of 2021, and many other questions. Then we face, and that is clear and is related to the group, we face an evolution very clear in the current European societies or Western societies, I include Canada, United States, about the right to know the biological identity and the origins among adopted children, for instance, as well the right to know the genetic also origins, like in the field of donation of gametes, or that's principally. Then, however, we see also through this case that the evolution of mentalities creates also new problems or many other problems, like and dilemmas for judges and authorities, because we have to take into account the rights of previous rights of third persons. Then the proposed legal argument in our judgment reflects certain problems and changes of perspective that sometimes is quite difficult to harmonize. And we are seeing this also in the assisted fertilization method, as I have said, with the insemination or by in vitro fertilization, or also, for instance, now with the maternity by substitution. Then what we have to face is someone wants to have a new right to know, the right to know, but others, we see that also another third parties, they are relying in law because the law has protected them previously. Then that's a legal problem about retroactivity of the law and security, legal security, and how to face this with this new, these new claims, we can say. Then in our concrete case in France, still exists a law according to which biological mothers can give birth under anonymity with the protection of the state. It exists an entire legal framework where it is possible to ask the help of the state to give birth in a hospital covered by the social security and giving the child in adoption. This regulation permits that the mothers with different difficulties could give birth in healthy conditions, and all the data about them are known by the state, but keep it in secret. In recent reforms, the legal framework has been improved, and it has been created this organism that I have said, this council, which permits now that the adopted children or anyone could ask to this organism to organize a mediation with the biological parents, if they are known. And then the system allows and promotes that the authorities could have also give all this information. They have it, if they have it, they can give it, but they have to respect also, we will see, the desire of the biological mother or father. Then it is true that, well, nowadays it is quite common that this organism transmits to the interested person all the non-identifying information. That is not a problem, allowing the applicant to understand the circumstances of his or her birth. That is also very important. Also, the national system goal is to facilitate the access to personal organs. But at the same time, as I said, they have to in order to provide the name of the concrete biological mother, it is necessary the mother's will and consent. Then we are confronted to these two rights, the right of the mother to privacy, and that is also protected under our convention, and the right to the daughter to know the name of the mother. Then what they did, this council, it was research about the situation, and they have found many information. Then, well, if the mother, of course, if the mother agrees, there's no conflict. Well, then, but the mother has to be asked. And in the French law, the desire or the wish of the biological mother is prioritized, is prior to the right of the adult applicant, in our case, to know her origins. Then we see that is, yeah, a very difficult issue for even for judges, no? Then in our case, the applicant was adopted in 1952, and she has already she's 56 years old. And then when her adoptive parents pass away, they discovered that she was adopted. And then she started to try to find out who was her biological parents. Then she contacted this council, this mediator, and then they discover many things about who was her concrete mother and also the father, and they obtained the applicant's adoption judgment and many other information. Then the mother was asked, I have calculated, we don't have the concrete age of the biological mother, but I calculate that at least she has to be 76 years old. And then the mother said that she doesn't want to give her name at any price, and not only now, but also after her death. Well, then, as you can imagine, but the problems started. And also, although the mother gave the name even of the father. And then the biological father was also asked by this council, and then he also refused to reveal the secrecy of his identity. Well, in both cases, well, they have discovered also that the mother had a couple at the time, and the couple imposed to her to give the child in adoption. Otherwise, he wouldn't marry her. Well, I'm probably, well, she has now, of course, after many years, a new family and probably, well, a husband, children that they don't know anything about her past. That's the question. Then the French society has had a huge discussion about this law, and they have decided, even if they have changed many other matters, like for instance, the anonymity of gametes, that now they have forbidden the anonymity of gametes, but they have confirmed this law. Then we have to, before the previous speaker was talking about inclusion and vulnerable groups. Well, that's the dilemma that in these cases, well, in France, if, of course, to be mother, single mother or mother alone, or is nowadays completely different scene as before. That's clear. But although in the French society we have new vulnerable groups, women vulnerable, different from before, that now they are integrated by migrants, women, for instance, women with Muslim background, or also the field of prostitution, many other profiles of single mothers, or for instance, yeah, women that they didn't consent to this sexual intercourse and they were forced or raped, or that is a little bit the profile of many of these women that still nowadays in France want to give birth with anonymity, and they don't want to go into abortion, because also if they have the child, always they have the possibility to recover a contact in future. Well, they decide to do that. Then, of course, they have now they are less, of course. I have the statistics, but and also many, I have to say 43%, they have accepted to give her name. I mean, the system of mediation is functioning, and others, they are not known, but still many of them, they don't want to give her name. Well, then in contrast, also, just to go on and to try to keep with the time, I want to explain the dilemmas of judges, because we have had also in the same chamber judgment of France about the anonymity of donation of gametes. And nowadays, before it was anonym, and now they have changed the law, and it's not possible anymore to go into donation of gametes without giving the name. Then it's the contrast. I mean, we have this kind of contrast in this field. Also, is involved the right of knowing the identity or origins. But well, and the even if the new law has eliminated the anonymity, they have the law has not a retroactive character. And in case of that someone has used the previous law with anonymity, they have to be asked, and if they refused to give the name, then they don't give the name to the children or adults that they are being created with this gametes. Well, and then, well, that's I think it's very, very legal problem of the retroactivity, like the prohibition of retroactivity, and the security and these new mentalities and new claims. Then, the question sometimes also has to be, it has to be created transitional periods to respect previous rights or rights of persons that they have used. Also the law and the state has protected them in the case of mothers or in the case of the donation of gametes, even if it is, I think it is quite different. Well, and just to finish about these difficulties in the evolution or the change of mentalities, in a country like neighbor to France, like it is Spain, we have our legislation is completely different from France, and we are in the European Union. I mean, it's not comparing to some country of the East or in another process of evolution, or I mean, very near. And in Spain, now, for instance, the right to know their own origins in the case of biological mothers is prior at any price, even if they don't want it, in face of the adopted children. That is our legislation. Whereas in donation, still in Spain, our law is completely, protect the anonymity of donators of gametes. Then, that's the problem. Then just to finish, about sometimes the perplexities of judges that we are in the middle of these changes, and when justice and as you say in the group, no, the consolidation of human dignity and privacy is not so easy to solve. Sometimes we can find an accommodation or reasonable adjustments, like the concept is used also in Canada, but another times rights are in conflict, and it's very difficult, or they cannot be both at the same time in this kind of matters. And well, it's what I wanted to expose, and then just to share with you these dilemmas that is going from the academia to the real world. That in theory also I have been defending a lot the right of knowing their own identity, but now, yeah, when you have to solve concrete cases, it's quite difficult. Thank you very much.
Thanks a lot, Maria. Thanks a lot. Well, now finally, we have the intervention of Henry Spalding. He is Jennifer and Samuel Tarry Research Scholar and Professor of Law at the University of Richmond, the USA. He will present a paper titled Forecasting Human Rights Legacies, a rubric for anticipating the human rights impact of mega sporting events.
The slides, can I get the slides? Okay. All right, and we're going to. Okay, sure. Okay, thank you very much. Great to be here. I am really grateful for this chance to present these ideas with the interest group, and grateful to do so in this particular country, which is especially relevant to my topic in ways that we will see in just a moment. My presentation is less about substantive emerging rights than it is about an emerging tool in the human rights movement, an emerging mechanism for promoting human rights, and that is mega sports. FIFA Men's World Cup primarily, but also the Olympic Games and arguably some other sports. I think we are entering an era in which we are discovering that mega sports have the capacity to leave positive human rights impacts in the host country. And I think it's important for scholars and stakeholders to recognize this opportunity, to build it out, to support it. And we will see in future mega sport events more of this, especially, hopefully, particularly, potentially here in Spain in 2030, as Spain is the principal host of the FIFA Men's World Cup, and I suspect winner of the 2024 Euro Cup. Okay, so I'm calling it forecast. What a great game that was last night. Calling it Forecasting Human Rights Legacies, a rubric for anticipating the human rights legacies of mega sporting events. I'll tell you what I mean by that. I want to be concise because I'd really like to leave a lot of time for discussion with all of you. So when we think of mega sport legacies, what comes to mind at first might be infrastructure, might be economic returns. Of course, the value of each of these is disputed, and this notion would elicit cynicism, I think, from most of us. But I want to expand your understanding of the legacy that a mega sport event can leave. There's a robust interdisciplinary literature on this topic, but we can also count laws, policies, practices, norms, knowledge, all as legacies of a mega sport event to the extent that the event leaves these things behind. So that after the event is over, everything okay? Yeah. Oh, okay. So that after the event is over, there's a lasting positive impact. We can call that impact a legacy. So could we imagine an anti-corruption and human rights legacy? I'm talking about human rights today, but I work on the corruption side as well. I'm sorry, excuse me? See, that's very distracting.
Yeah, that's what I was just trying to defend my rights, actually. Yeah. Right to privacy harassment, I'm so sorry. But I trust you, you will leave me alone in peace and trying to follow the lecture here.
I'm sorry, I'm so sorry.
I'm so sorry for the interruption.
Okay. Okay. So.
Yeah? I just hope this has been effective. I don't need a lawyer, I'm a lawyer myself.
I'm sorry, I'm not sure. I'm just gonna continue. Okay. Okay, so, as I was saying, I talked about human rights today. I work on the anti-corruption side as well. I'm trying to define human rights and anti-corruption legacy as a set of laws, policies, practices, norms, or knowledge promoting anti-corruption and human rights goals that have an impact beyond the event itself, that remain in place after the event is over, the adoption of which is accelerated by hosting the event. We don't have to make the argument that the event caused the reform, but the event can accelerate the implementation of the reform. And to the extent that has happened, we can call it a human rights legacy, consistent with this broader interdisciplinary literature on megasport legacies. Okay, so from there, I want to think about how we can, as we are anticipating future events, as Canada co-hosts with the United States, the FIFA Men's World Cup in 2026, as we will in Spain for 2030 and beyond, how we can think about the most likely positive human rights impacts in a country. And this work is framed by my experience in Qatar. Qatar was, of course, a watershed moment for the human rights impacts of mega sports. We likely know about some of the human rights issues that arose. What we may not know, because it was not widely broadcast, is the positive human rights impacts that hosting of the World Cup left in Qatar. We largely don't know that Qatar, in response to the Western criticism, completely reformed its national labor law system. Okay. Now, there are questions about whether the reforms will last or whether they will be fully implemented, and those questions are yet unanswered. But there can be no doubt that if we were to measure the extent to which a host country used a megasport event as a lever to implement national reforms that had application beyond the event itself, not only would Qatar score highest on that metric, I don't even know who the close second would be. Okay. It's astonishing what Qatar did, and we don't know about it. It wasn't widely publicized. Okay. At the same time, while that was all true with labor rights, where Qatar also received criticism and did not respond was on the LGBTQ piece. There we saw a very different response from the host. On labor, Qatar largely leaned into the criticism and responded by, again, using the event as a lever to push through reforms that remain in place after the event. On the LGBTQ issue, did not. You saw the opposite. You saw resistance, even principled resistance. You heard Qatari say, we have our own values here. So juxtapose those two rights widely recognized in the international community, right? Substantial international criticism of Qatar on both of these rights. On one right, Qatar really leans in. I can see in your faces you don't believe me. That's a conversation for another day, okay? But I would argue that they did. And on the other right, Qatar resists. Okay? How do we explain the difference? What I'm going to present to you now is a rubric I'm trying to develop that would explain that phenomenon and would help us explain or help us predict the impacts in future host countries. Okay? So, hope we can all read this. This is a simple graph. The point of this graph is not to measure anything with precision, it's to frame our thinking about these issues. So first, on the vertical graph, I want to distinguish between an intrinsic human right issue and an extrinsic human right issue. Intrinsic and extrinsic to a megasport event, okay? Intrinsic is a human rights issue that the event itself will touch in a substantial way. Labor rights in the construction of the venues for the event. Okay? That human rights problem, labor in Qatar, throughout the Middle East, was pre-existing. The event now is going to come and exacerbate that right in a substantial way because, in this case, the event depends on the labor that these underrepresented workers will provide. Okay? Extrinsic is something else. Extrinsic is a right that is a human rights issue in the country, but that the event isn't going to touch directly, particularly. Take, for example, capital punishment in the United States. Okay? It's a human rights issue. There will be a lot of discussion around that issue in the next 10 years as the United States hosts a series of mega sporting events. But these events that the US hosts is not going to touch the capital punishment issue. You're not going to see some kind of increase in executions for people's conduct related to the mega sport event. That's absurd, right? So you see the difference between an intrinsic event and an intrinsic issue and an extrinsic issue. Okay. Let's think of the horizontal axis, and this piece is under theorized. I would say I would welcome insights from anybody on how I might build this out. I want to distinguish between a principle and a practice. Okay, that might not even be the best language, and I'm open to responses here. Okay, a principle is an idea that is deeply rooted in the public philosophy, the ideology, the culture, the history of a country. Okay. It is something, it is a norm that people will proudly defend in public. We can trace it back to historical events, to founding documents, to key texts in the culture and history of a country. A practice, by contrast, is something that might very well be entrenched, might be supported by law, but is not something that people would proudly defend in public as a matter of principle. So, for example, in the United States, we'll stay away from that one. I'll come back to Qatar. The LGBTQ issues, the resistance to this anti-discrimination norm on the LGBTQ piece, I would contend in Qatar was experienced as a matter of principle. We have our own values here. We have our ways we justify our values. We can identify them in texts and in history, right? We're not just being stubborn here. We simply don't agree with your norm. The labor issues were very different. The labor issues, the lack of an enforceable minimum wage, the confiscation of passports, the lack of freedom of movement, the failure to enforce contracts, that was pervasive, that was supported by the government, but no one's going to defend those practices as deeply rooted in the history and culture and the traditions of the country. In fact, quite the opposite. You saw a number of historians and Islamic jurists saying these practices have nothing to do with their historical origins. This is a distortion of what we have historically done, what we have historically believed. Okay. So we can distinguish then, and again, I'd love to hear feedback on this, between a principle and a practice. we can distinguish between an extrinsic issue and an intrinsic issue. In very rough ways, we could think about the probabilities of lasting human rights reforms in this way. Where a human rights issue runs up against a practice, not something that people will defend in principle, and it is intrinsic to the event, we're going to have a relatively high probability that the event, the hosting of the event, will lead to lasting reforms in the country. Okay? When the world says, we don't think you should do this, and there's really not much that can be said in response, except that it's profitable and convenient for us. Okay? There's more opportunity there for reform. Where the event is going to exacerbate that rights violation in a very real and serious way, the criticism is going to be that much more relevant and pronounced and supported. As opposed to a principle where you will see principled insistence that the norm just isn't applicable here. And it's an issue that is extrinsic to the event, so it's not entirely clear that the human rights event is going to relate to this human rights issue. It's there in the background. We'll have discussions about it, but we can't say that the event is exacerbating this problem. Low probability. I would suggest that one way of explaining why Qatar moved so far on labor and so little on LGBTQ anti-discrimination is that while both are intrinsic to the event, LGBTQ piece maybe slightly less so, but both were intrinsic. Okay, what we saw is the labor is a practice, so we're up here in this quadrant. The LGBTQ stuff, more of a principle, and we're somewhere over here. Okay. You can think about issues like again, capital punishment in the United States. Extrinsic, we could argue about where it goes here. Historically, it would be somewhere over here. I think more recently, it's moved in this direction. How far is debatable. But even so, because it's so far here on this axis, I think unlikely we're going to see a lot of issue there. However, the United States does have its own labor issues. You may know about that. And there, I think it's intrinsic and closer to a practice. I think you aren't going to hear major corporations getting up in public and defending the employment of illegal immigrants without honoring their labor rights. That's just not going to happen. They'll resist in other ways, but not in that. Last point, and I would love to hear your reactions. I'm taking less than 20 minutes because I want to preserve time for discussion. I have thought, comparing now just Qatar and the United States. Is there an analog in US legal and political culture to the LGBTQ issues in Qatar? That is, where it was an issue that is maybe middle of this axis, but very much a principle. Where in the United States, you will hear people say, we have our own values here. That you, the international human rights community, don't validate this is simply not important to us. I think it's this. I think it's guns. I think gun rights are to the United States what LGBTQ discrimination is to Qatar. And I think as mega sports come to the United States, you're going to see a lot of discussion about guns, gun safety, gun rights, fear of gun violence, the peculiarity of this ongoing defense of the right to a handgun from the Supreme Court. You're going to hear all of this, and but you're not going to see much movement because it is so deeply embedded. As opposed to labor in the United States, where I think there's a high probability we'll see reforms there. You could plug all kinds of issues into this and think about it. Again, we could dispute where they might go on one axis or another, but the point is to frame that discussion, to catalyze that discussion and get us thinking about likely impacts. And then by extension, where stakeholders, host cities, municipal and state governments, corporate sponsors should invest their resources. where do we think there is an opportunity for reform and where should we focus our energies? I think there's a thought in the human rights community that there's a lot of heat generated around some issues where there's just not likely to be any improvements. That has its own value, but when we're talking about reform, I wonder if this is helpful. With that, I'll stop and I'd really like to hear people's responses. Thanks.
Okay, now it's time for questions, whatever you want, to the person who prefer. It's, I will ask you to do a brief presentation. Hope you know me already.
Thank you very much. So thank you very much, Colleen, and
Okay, sorry, a brief presentation.
yes,
you
yes,
said.
yes, just this eco-social constitutionalism. And
Okay, please, your name.
Introduce yourself.
Sorry, Jorge Portocarrero, Universidad Nacional de Educación a Distancia, UNED, from here from Madrid. And I just want to ask you if you can elaborate a little bit more on this eco-social constitutionalism. You go a little bit quick over that because it seems to be a concept which integrates two important problematics like environment and environmental injustices and social injustices, and how can constitutionalism deal with these two problematics? So it's kind of a revealing concept for me because this is really concentrate all the discussion in this one encompassing concept of eco-social constitutionalism. If you can elaborate a little bit more on that. And for Professor Spalding, yes, you developed this chart, and you use as some concepts. I'm not sure if it's the same theoretical language we are using, like the word principle. The word principle, it seems you use that as a synonym of value, and not as a value such as just a guiding policy, a guiding idea, but really as a social rule. So value which has to be followed in a strong way, because principle. If I think of Ronald Dworkin or Robert Alexi, the people who have written about principles, they don't put principles in the way that they are like this kind of a deep feeling or deep conviction, deep idea into the society. Are actually Dworkin claim that principles are reasons in one direction that suggest a certain decision, but not in a definitive way. In the same line was Robert Alexi when he defined legal principles. So I think that perhaps a principle here is not the right or not the most suitable idea of a concept to be used. Perhaps a strong value would be the best way. And the question for you is how to measure low, moderate, and high in your because it's how to differentiate between moderate and high, and how because otherwise you can have just a broad approach, a broad scheme, but not really a clear definition or distinction between these quadrants you have present. Thank you. I'm sorry.
Thank you. So, Colleen, I don't know. You prefer the
That's fine, no, I can
questions?
respond. No, I skipped over a little bit the eco-social constitutionalism for reasons of time. But it resonates with the legal pluralism, but I actually took those ideas out of an editorial by James Tully and others in a journal on global constitutionalism, and I can give you the full citation. But what's interesting, they talk about two types of emerging forms of constitutionalism that are needed to address the major global crises of the day: environmental violence, socioeconomic inequalities, etc. And one is contestatory constitutionalism, which is using the formal channels to go to court to bring big environmental claims, what have you, or social justice claims in the courts. The other was much more of a constitutionalism from below, and drawing a lot on Latin American initiatives, actually, and the sort of earthways of indigenous peoples, some of the work of De Souza Santos, and which is the idea that there are patterns of relationships and living. Instead of worrying about what the formal legal system is doing, peoples are developing alternative ways of being. And in their conception of global integral constitutionalism, they emphasize the need to do both, to be using the formal system in imaginative and important ways to advance rights, but also to recognize the ways in which this alternatives, people are living alternative ways of governance and relationships. So I think I can't really do justice to it today, but I can give you the citation for the article because Tully and his colleagues really develop it much more fully than I have today. But it takes us out of simply focusing on, and it's relevant in Canada because Indigenous communities are doing this a lot. They are regenerating Indigenous law. And it's outside of our formal constitutional norms, but they're referring to it as Indigenous constitutionalism, and it's connected to the earth, and it's different from our normal human-centered ideas of law. So I find those ideas quite intriguing. Yeah.
Yes, thank you very much. Thank you, Colleen. Maria? Richard, if you want.
Yes, well, I have a question for Colleen Sheppard. May I?
Yes.
Yes, okay. Well, I have been very interested in your approach on the access to justice in courts and tribunals for vulnerable people, and then also you spoke about the role of the state, of the responsibility to facilitate this access. Then I would like to ask you, or if you, of course, you have written about that, and we have a very few time, but if you have some concrete proposal about this, how it can be done in reality, or some good experience on that.
Well, shall I respond to this right now, or do you want to respond? Okay. Well, the access to justice and access to tribunals and courts, I think, is absolutely essential and integral. But my experience actually goes back for 20 years when I was a commissioner on the Quebec Human Rights Commission. And what I found was that we would have a complaint of a denial of an apartment rental on the basis of race. And by the time we got it, it was 3 years later. And so the individual who had been denied the rental, they may get their day in court eventually and get some kind of a remedy. But I started to think about alternatives to access to justice. Now, I think, as I say, I think it's critical. And what I find in Canada is that you have a lot of community-based organizations, NGOs, even trade unions who are facilitating individual access to justice. And those individual claims humanize the law because they raise the stories, like the case you spoke about in the conflict of rights are poignant, and they crystallize our understandings. We're not left totally in the domain of theory. But so I think access to justice is important, but one of my colleagues, Rod McDonald, who's no longer with us, in his work always emphasized that access to justice doesn't simply mean access to courts. It means access to real justice, real just outcomes. And for that, I've been trying to think about alternatives. If we see violations of human rights not as anomalies and individual anomalies that can be redressed through retroactive complaints processes, but instead see violations as more systemic and structural, then we need more systemic and structural legal responses, which takes us into these new regulatory modes of institutional regulation, those kinds of sort of proactive laws, responsibilizing, that's a word, institutions. And also, I think, public debates about how we need to change our regulatory frameworks to ensure that we address these broader structural injustices. So I don't know if that answered your question a little bit, but I'll stop there. So.
Thank you very much.
Yes, and we only have a few minutes left, and I really want to save time for questions, so I'm just going to be very brief. Whether there is confusion that's created by using the word principle in a way that's different from, say, the way Ron Dworkin uses it, that's a fair point. I have to think about that. I'm just not sure what other word I can use. Maybe just making that distinction clear in a presentation will help with that problem. How will I ever measure clearly the difference between moderate probability and high? I won't ever. Because it's not really what I'm trying to do. I'm just trying to suggest a vague degree of likelihood. I'm not ever going to measure anything with this graph. And so it's not historically not typically what we do with graphs. I recognize that, but it's just the best way I could devise to kind of frame up this issue. The economists would not like it.
There was a question there.
Yeah, please.
Hello to everyone. My name is Maria Diaz-Grego, and I currently work at the Spanish Constitutional Court. Thank you very much for your very rich presentations and suggestive presentations. I had a question, a very short one for you again, for Professor Spalding, if I am right. I was somehow, let's say, puzzled by your proposal, and I was wondering, or your ideas, and I was wondering whether you could maybe give us an example of a long-lasting change, let's say, in human rights legislation or human rights practices in a country because of let's say or cause or link to a mega sport. Because I was thinking that maybe those changes just happen in a period of time and then they were reversed.
Okay, that's absolutely right. And on the Olympic side, they define a legacy as an impact that lasts for one full Olympic cycle, which is 4 years. So the question is not whether in the immediate wake of the event, we have a lasting impact, because it hasn't lasted yet. It's a question of how many years later do we wait and to see. Take Qatar as an example. Qatar is really the first host country that said, we're going to leave a human rights legacy. And this is what we're going to do. So the question is going to be 4 or some rough number like that years later, are the statutes still in place? Have they been enforced to a meaningful degree? There will have been pushback. Has the pushback been resisted? Can we say in X number of years, 4 or whatever, that Qatar remains in a different place than it was pre-event? And can we say that the event was difficult to prove? Very likely was an accelerating factor there. Frankly, I think because the ILO, this is more details than you want, the ILO continues to cooperate with Qatar in implementing its labor reforms. I think the likelihood that 2 years from now there's a strong legacy argument is actually very high.
Thank you. I'm Javier Moreno from the University of Barcelona, and I wanted to ask a question also to Professor Spalding. I found the presentation very interesting, very stimulating, but I have a question regarding the top left part of the axis, regarding the intrinsic issues and that are based in principle. Because for me, for example, in the case of Qatar, it's kind of hard for me to not see the LGTB rights as an intrinsic issue in the event. It was like a whole topic, like the bracelets, the flags was like an LGBTQ fans and etc. And I think it was kind of an important issue at the moment. And there was no possibility of change from the Qatari government. And that leads me to thinking, when we refer to moderate probability in that scenario, what is the mechanism that might actually lead to some change when it's a principled matter in the state? Because, for example, I can see when it's not, which is a matter of practice, the event might lead to a change of incentives of different state actors and private actors, because when you agree that it's what you should be doing, but you don't do it because of certain issues, which is a matter of practice, incentives may change. But when it's like a theoretical core issue, I'm questioning what the mechanism would be that this kind of events might with a moderate probability change this.
Yeah, on the, for lack of a better word, principle stuff, I think, again, probability is lower, but there is, and in other areas of legacy scholarship, this has been documented, where there changes in attitudes alone constitute a legacy. So for example, people don't know this, but in Qatar, it was the first megasport event that had teams of UN trained human rights observers at every stadium for every event. And I got to lead one of those teams, and it was fascinating to see what was happening on the ground there. A very vivid image I had was of a group of young men dressed in traditional clothing, processing toward, maybe there were a dozen of them, processing towards the stadium and chanting together, "Everybody's welcome, everybody's welcome," right? Raises the possibility, did the hosting of the event create dialogues within the country that may have changed some people's attitudes? 4 years from now, if we could design the surveys and implement them reliably, and I'm not the person to do that, but somebody else probably could we show that people moved a little bit? I had the good fortune of being at a meeting of kind of stakeholders to the event. It was called the Doha Dialogue. And there was a woman there from a high-ranking official from the government. A human rights interest group was insisting that the government issue a statement that members of the LGBTQ community will be safe in Qatar. And she said, we don't change through statements. We change more subtly than that. There's not going to be an announcement. There's not going to be a policy change, but you will see values change slowly over time. If we could measure that,
we have some minutes. Any more questions? Well, yes, you. No. So, three small questions, please. Andrew, what about the right of using in the United States in the future? Second, Colleen, how much constitutional dogmatic studies and how much legal sociology in that creation of the social constitutionalism? Methodological question. I mean, Maria, is there any possibility to do a distinction between the mother's identity and the mother's desoxyribonucleic identity? I mean, the problem is the transplantations, no? In the French tradition, it could be a different treatment for that, two different situations. Okay.
will there be change in the future in gun laws? My answer is no. I think there's going to be dialogue. I think that right is becoming very deeply entrenched in a short period. Those roots are growing deep and fast in the legal system, and I don't think so. But I also think Americans don't realize how crazy this seems to the rest of them. And maybe when there's dialogue around it, people's eyes will be open to that. Okay.
I don't know.
I don't know. So here we go.
No, I mean, I guess the idea I was trying to present was that we have our legal concepts, especially human rights, which are open-ended and subject to multiple interpretations, and then you have conflicting rights as well that come into play. So there's a lot of uncertainty, interpretive space, and so how do we give those legal norms some meaning? And I think for jurists, it's a challenge. And the idea of substantive equality has been one which has been controversial, because some people, there was a move towards more of a substantive conception of equality, and then there's been some backlash against it because people are saying it's too fuzzy, we don't know what it means, how do you apply it in these different contexts? You're bringing sociology into law, it's not a legally objective idea. So I guess I've found though in the past, sometimes when we look outside of our law, usually it's when I'm on sabbatical and I'm not just teaching Supreme Court decisions all year, that certain ideas from other disciplines can help provide some clarity in our frameworks and in our understandings. And now what proportion is that? I'm not sure. I mean, as it may depend where you're sitting. If you're a legal scholar, you have more space for drawing on legal sources. If you're a judge, I think you're much more constrained in terms of the kinds of interpretive sources that you have access to. So I don't really know what the proportion would be, but I think it's important for us to, at least I've always found it most interesting to look outside of the strict contours of law to try to gain greater insights into
Mhm. Okay, yes, thank you for the question. I think that, well, in France, both situations are seen as that they are not the same because of, I think, some gender perspective. In the case of the mother, biological identity is seen also danger of discrimination of these mothers in the past and in the present. That's why they want to keep anonymity. But in the case of gametes, normally are more men who are behind, and we can say the identity by these men or that they gave sperm is not the same as a mother who has had the child. I think that they see these situations as different.
Well, since David, may I ask one little question to Professor Sheppard? Yes. Well, thank you for your presentation. I am just wondering, how would you answer the challenge of those who affirm that the recognition of some new rights or even the one that have been recognized in international instruments is not the proper way to solve this huge social injustice because of the mechanism we have to solve, an individual mechanism. So how can we, and you have talked about prevention, how can we answer this challenge?
Okay. Well, I mean, maybe I've been working on constitutional rights, human rights for a number of years, so I have that sort of professional bias where I believe in human rights and in the possibility, their positive potential. And yet there's a lot of critical scholarship about problems with the rights paradigms. And also there's a risk that certain rights can be framed in ways which will actually perpetuate certain kinds of injustices. So that's one idea. But the second thought I think that your question raises to my mind is that I think we need to move towards prevention of human rights violations. And that means looking at how institutions operate. Just to give an example, if you think about sexual harassment, and if in a classroom there's an issue of sexual harassment, once that happens, it poisons the entire environment, of learning environment. So you want to prevent the harm before it occurs, because some harms can't be redressed. They can be redressed through some money and through some kind of change in future policies, but the prevention piece is very important. And that means looking at human relations and practices and in different contexts where people live. I mean, if you're thinking about in the workplace as well, if you really want to implement human rights in the workplace, you want to ensure that you've got committees that are making hiring decisions that are fair, and you're not just talking about going to court to address it. So I guess that maybe answers that a little bit.
That's the meso level you're referring to?
What's that?
That's the meso level you're referring to?
Yeah, the meso level. Absolutely. Yeah, that's what I'm looking at a lot. That it's sort of that systemic institutional level. What can we do at that level? And also, but it's related to the individual and the macro.
I'm gonna try to explain in English. I'm Alejandro Sawi from University of Campeche in Mexico. And as I loved your presentation and the line of the question that Professor Sauka made. I think that if you can recognize the agency in two lines, autonomy or self-government that are represented by in Constitution by human rights, autonomy, and self-government democracy. You can make some traductions in the line of the language of the Constitution. So it's a better way to introduce in the practices, in the structural practices, the social practices. You can recognize the agency of the persons. But if you use notions like autonomy or self-government, you can better understand that if you use only the concept of moral agency. Yes, because you are using already notion that Constitution recognizes. It's a mechanism of traduction or translate. It's an argument that you can recognize in the debate of Habermas and Luhmann.
Don't look at that again. That's an interdisciplinary.
Yes, Luhmann has a book about human rights. Very interesting in that line.
Yeah, interesting. But the agency, but using those concepts, both of those are very much group or community related of governance, self-governance, and autonomy. As opposed, moral autonomy is more individualized.
Yes.
I just wanted to present one idea that I found useful. I think the agency thing is critical. Some scholars also mention the idea of partial agency. So you're not using a victimization term, but you're not suggesting that everyone has full agency. And that what our laws should be doing is reinforcing partial agency towards greater agency, which may be through certain governance or recognition of self-governance.
Thank you.
Vamos a seguir en la conversación.
Yeah.
Well, any last question? Okay, so thank you very much indeed to the speakers. I think we have many different things, many different issues, and many different dimensions to be studied in this way of emerging rights. And so if you want, just make the registration at the website, and we will begin having communication in order to develop and network. So thank you very much.
Thank you.